Now that's $1,000,000 question. We're talking about misrepresentation. Suppose that, a person, the other party who basically wants me to sign the agreement, fails to disclose something fails to disclose something to me. He actually fails to disclose that by signing the contract, I might be able to be tempted to, do several things. I might, do several things. For example, make an investment because I'll be having a lot of money, an investment which might turn out to be bad for me in the long run. So he fails to tell me that I'm going to be tempted. Now, let's say that I signed the contract already, and as a result of that, which is a loan, let's say it's a contract of a loan, I got some money, and with the product of the loan, I decided to make on that investment. Or an investment actually was later on misrepresented to me by that party. The same party actually made the loan contract to me. Can I claim misrepresentation in the sense that he failed to disclose to me that I might be tempted to go on and make that investment, or go on to make another act? I might be tempted when I've signed that contract. Well, most likely answers to that should be no. That's not a misrepresentation, and the reason for that is that it is not a statement of fact. It's not a statement that is not a fact that has not been disclosed, that has been hidden from me. And if I had known, I would have otherwise not entered into that contract. It's basically something which I have no control of. If I'm gonna be tempted, that's just me, and it's my right to be tempted or not. It's not like an obligation. So when I have signed the contract, I will, when I have signed the contract, there's nothing to bind me to go on and make that investment. If I was misrepresented by that party to make that investment for a different set of circumstances, different set of rules, unrelated to that existing contract, that's a different story. And I can opt out of that investment on the basis of those representations. But to say that I might have been tempted is not a statement of fact. It's not something that wasn't a fact that I was going to be tempted. And I don't think that temptation is something that locks me into the agreement, and I can have control of my temptation. Now, if, for example, he knew that I was some kind of that I had some kind of a compulsive condition, and had I known that I had a lot of money in my disposal, or the only means that I could actually make that investment was that loan, and didn't tell me, would that be a misrepresentation? Well, then again, let's say that I was an addicted gambler and I wanted to make that investment. The only way is the loan. Well, if I made that loan in order to make that investment, then that's not due to the misrepresentation. That's due to my own personal reasons. It was something that I deeply knew. Was something that I knew when I was actually signing the contract. Now, if I didn't know that I was gonna make that it would have had an effect on me, well, by getting the product money, which totally sounds totally unrealistic. I don't know that with the money I might be tempted to make, to go and contract and to go make a bad investment for myself. I don't know, would the reasonable person have been induced? Would the reasonable person had relied on that statement, which was actually hidden and was not disclosed to me, that I might have been tempted? I don't think so.